Right now on Law and Crime Report, a hearing date set for Chad Daybell. A judge has already ruled that Chad Daybell and Lori Vallow Daybell will be tried together. Now a date has been set for a motion to dismiss charges and change venues. Plus, Gloria Allred discusses the Bill Cosby appeal and why the prior bad act witnesses are so key to keeping Cosby in prison.
By showing the testimony, allowing the testimony of prior bad act witnesses, it shows that Mr. Cosby was not mistaken about whether Andrea consented.
And later, the body of a missing social media influencer winds up on the side of the road, why her mom suspects foul play. This is Law and Crime Report, diving into true crime and all legal stories making headlines. And welcome to Law and Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. We're going to start with the ongoing legal drama of Chad Daybell out of Idaho. Daybell, along with his wife, Lori Vallow Daybell, are in jail, and they're waiting trial on charges related to the grisly discovery of Lori's children, Tylee and JJ, found buried in Chad's backyard. Now, what we have learned is that on January 6th, Daybell's attorney, John Pryor, is going to argue for a motion to dismiss and a motion for a change of venue. The last time we saw Chad in court is when his legal team was trying to fight to keep him separated from Lori Vallow. He did not want to be tried with her. He wanted a separate trial. Take a look at that argument.
I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations, against Mr. Daybell and Ms. Vallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I filed talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that.
Okay, let's get right into it. I'm joined right now by trial attorney Andrew Cherkasky and crime analyst and former SWAT team member Lisa Lockwood. It's great to have you both here. Andrew, I'm going to start with you, and I'm going to start with the motion to change venue here. Where on earth could they hold this trial that somebody wouldn't know about it? This is the biggest case, one of the biggest cases to hit the country, and everybody's going to be watching on it. I know it's out in Idaho, but people everywhere know about it. So where do they actually, what are they going to argue in a motion to change venue?
Well, I wonder sometimes how much the rest of the country knows about things, because we're here talking about these cases all the time, and they are huge cases, and this case specifically is huge. You know, when it comes to a change of venue, sometimes it's just getting out of the heart of the county in which it's occurred in, because that's where people are talking about it every day, all day. The news covers it for 15 minutes of the 30 minutes of the local news. That kind of heart of the zone is where you see the issues. And so they try to take it to other parts within the state, maybe on the other side of the state. That's what I typically see in a change of venue in a state case, to get it out of that very intense area of discussion about the matter.
Lisa, we can't forget that Daybell, he's charged with 2 felony counts of concealment of evidence, 2 felony counts of conspiracy to conceal evidence. Basically, that he helped to, dispose of these bodies on his property, cover it up, keep the police away. When we talk about a motion to dismiss, we can get into the legal standard, but based on the evidence and based on this crime scene, what kind of argument do you suspect we're going to hear? Is he just going to say, oh, I woke up one day and my gosh, I didn't know that they were there? Again, what does the evidence show? What does the crime scene show, Lisa?
The fact that the police were able to go forward and file the report against them shows that they had enough evidence to proceed with it. They needed authorization from the state's attorney in order to get the charges initially. So that would have been the points where they can combat it and say that it wasn't a true bill to go forward. So having these deceased bodies on his property of his new wife, he was married 2.5 weeks after his wife died, and we're still waiting for the results on that. It's going to be very hard to try to prove that he wasn't part of it because it was on his property.
And that's what makes this so interesting. The fact that you have Lori Vallow, Daybell, Chad Daybell, by all accounts, concerted effort. They seem to be, aligned. And yet, when we played you the portion of that hearing, Lori Vallow didn't object to the fact that she wanted to be tried with her husband, but her husband sure did. Gives you an understanding that these are 2 different kinds of cases. And ultimately, it was up to Judge Boyce to make the decision on if they should be tried together. Take a listen to this.
It's pretty clear that the first prong of whether or not there's a common scheme or plan is supported under Rule 8B for joinder of the offenses in this case. And then looking at whether or not the joint trial of the 2 defendants would be prejudicial. There was an allegation in the response that was filed that this would create additional publicity, which would prejudice the right of Mr. Daybell to a fair trial if these cases were joined. I've considered that. I've also considered the arguments of the state that having 2 separate courses run in 2 different cases with 2 different judges could result in separate evidentiary rulings. There could be some inconsistencies. There would be duplicative hearings. And I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point, the prospect of having 2 separate trials where 2 separate juries would have to be impaneled to try each case is concerning as well. And so when I look at all the factors and the supporting case law, I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. That's where a single defendant had a trial involving separate multiple victims, which were put together in a single trial. Here we've got 2 defendants with a single common scheme or plan that is alleged. And so upon consideration of all that, counsel, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if prejudice is demonstrated by the defense in support of that motion.
So Lori and Chad are going to be tried together, their trial in July of 2021. Andrew, I'm going to ask you a two-part question here. A, are we going to see a trial in July of 2021? And is that because either do you think that Chad Daybell will win a motion to dismiss and gets these charges thrown out? Or B, there's a long time between now and July. Could a deal be worked out or there be some issue? So it's kind of a two-part question if we'll see a trial in July of 2021.
So, Jesse, let me look into my crystal ball and tell you that I think that the case is well set. That being more than 6 months out, I like a trial date like that. It tells me that that date would likely be kept. I think you ask a great question with the plea deal. This is a deep psychological sort of assessment here that I think would be fascinating to be in the discussions with the attorneys, because what we see between Chad and Lori Daybell is some sort of kind of twin flames romance that these two seem to have lost sight of any humanity in going forth with their relationship. So I would tend to think these are not people who are going to turn on the other. But in this case, just looking at the facts, it seems as though perhaps one is significantly more culpable than the other. My assumption is that's Lori. But if there is one person who can turn on the other and provide great state's evidence, I think that there's a decent chance. But to what end? Is there any sort of reasonable deal here where somebody's going to be out in 10 or 20 years? I think everybody here is looking at life. So what deal is there? So to answer your question, no,
okay.
I don't think there's a deal.
Well,
yes, there's going to be a trial.
Lisa, let me ask you this. We have about a minute left. So people are going to hate me for saying this, but I have to ask it. You know, the idea of one turning on the other, nobody believes that's going to happen. However, there is a difference in cases. In your experience, as much as two people love each other, as much as they're in the same boat,
Sure.
it's a long time between now and that trial. Do you see a difference in these cases on who's more responsible, who might turn on another, who might blame another? Again, we're seeing a little bit of a difference in legal strategies, even though they're represented by the same law firm. So what do you think?
I agree with Andrew. I believe that Lori has more to lose. So Chad would be the person, if anybody, to go forward with this, because the assertion is that Lori's brother was behind this. Lori's brother was last seen photographed with the children before they went missing. Lori's brother, as we know, is now dead from a pulmonary aneurysm. So the fact that it's a family member that may be responsible for it, Lori's, and maybe Chad had nothing to do with it, but he wanted to protect his wife. He has more power. He has a better hand.
Well, it's a case we're going to continue to follow. It's one of the fan favorites here, and who knows which way it's going to go. But I'll tell you what, we're going to take a break. When we come back, we're going to focus on an update in the Bill Cosby case. It's rather unexpected. We'll be back. All right, welcome back, everybody. We're going to focus now on Bill Cosby, the disgraced comedian who was convicted of sexually assaulting Andrea Constand. He's currently serving a 3 to 10-year prison sentence out in Pennsylvania. And yesterday, the Pennsylvania Supreme Court heard his case. And it's all about whether or not they're going to throw out his convictions and maybe order a new trial. One of the most pivotal issues is whether or not it was right and fair and just for the lower court, the trial court, to allow the testimony of 5 women who testified about things that Cosby wasn't charged with. These are sometimes called prior bad act witnesses, and generally it's not allowed to include their testimony. It's prejudicial. You can't just say that the defendant might have done this or allegedly did that. He's a bad guy. He did bad things. That means he must have done this. No. What the prosecution said is they called these witnesses to show a pattern that Bill Cosby continually, over time, drugged women and sexually abused them like he did with these women. That was the case. Well, the Pennsylvania Supreme Court heard it. I'm going to get into what they said in a minute, but we actually had the opportunity, Brian Buckmeyer on the network had an opportunity to sit down with Gloria Allred, the accuser's attorney, and here's what she had to say.
I mean, the test, Brian, always is the admission of the testimony more probative than prejudicial, or is it more prejudicial than probative? Of course, the defense argued that it was more prejudicial than probative, Of course, all evidence that are presented by the prosecution against the defendant is always prejudicial to some extent. In other words, it would tend to argue that there should be a conviction. But the prosecution argues here it was more probative than prejudicial, more likely to lead to the truth about what happened. And that is why they wanted to admit and did ask to have admitted the testimony of prior bad act witnesses. It was as a form of corroboration for Andrea Constant, who was the only victim for whom charges had been filed.
Andrew, let me start with you. It seems, based on what the justices said, we may be in territory where they throw out his convictions and order a new trial. I mean, these are some of the comments that we heard yesterday. One justice said having these women testify was extremely prejudicial. Another justice asked, why would you even need these witnesses to testify at all? Another justice said, you could see how the prosecution was using these witnesses to show a pattern, but how? And then another justice called out that these claims were so old. Based on these comments, what do you think they're going to do?
Well, Jesse, this is what I practice in my criminal practice more than anything, and that's sexual assault defense. And I used to be a special victims prosecutor. This question of other allegations of sexual assault to prove one case in front of you is an extremely problematic area in the law. Prosecutions have pushed more and more and more in recent years to bring in that sort of evidence, and judges at trial levels have continually allowed that in a progressive manner. That's not always a bad thing because there are a lot of bad people out there who've done this many times before, and there's just not enough evidence on those other cases. The problem is, traditionally in American criminal jurisprudence, the idea of a past bad act to prove the matter before the jury is typically inadmissible. Why is that? Because it is so damaging. It is so prejudicial. And Ms. Allred got the standard a little bit wrong when she's saying it's not just a tipping of the scale. It's more than that. It's all of the factors. It's the time involved. Because at the end of the day, if somebody wouldn't have been convicted but for the claim of somebody else, now you've got trials within trials. And how do you do that as a defendant? How do you defend all these various cases where the other people aren't held to that standard of beyond a reasonable doubt that's guaranteed to a criminal accused person? Very complicated issue. The inherent notions of fairness are what the Supreme Court is looking at here. And at the end of the day, I think there's going to be some very unhappy people when this Supreme Court comes out and makes some case law.
It's incredibly important when you think about that when Cosby was tried the first time, only one accuser was allowed to testify. The jury was undecided. They couldn't decide on his guilt, and that was a hung jury. And then we ultimately had his second trial. 5 women were allowed to testify. He was convicted. You mentioned Gloria Allred got the standard a little wrong. Well, here's another part where she talks about the importance of these prior bad act witnesses. Watch.
Of course, the acts that were testified to by these 5 other prior bad act witnesses, they were not, they were not reported to law enforcement, the defense argues. And so that they're more prejudicial than probative. But of course, the prosecution would argue that, yes, that's true, they weren't reported to law enforcement, but they did tell others about it. Maybe it was a family member, maybe it was a friend. And anyway, the prosecution argues, look, it's important on the issue of consent, absence of mistake. And that means that they wanted to prove that Cosby, who they argued, said that Andrea consented to drugging or sexual assaulting, and so it wasn't sexual assault, according to Cosby's team, that she consented, that by showing the testimony, allowing the testimony of prior bad act witnesses, it shows that Mr. Cosby was not mistaken about whether Andrea consented. Because look at the testimony of the prior bad act witnesses. If he is drugging and sexually assaulting other women, he knows that if a woman is incapacitated by alcohol or drugs, she can't consent. He's not mistaken about it. He's doing it so that they can't reject him. In other words, not consent or consent. They're incapacitated. And that is why they wanted to show it. That, and of course, because they want to prove a common plan, scheme, or design that Mr. Cosby had.
Okay, Lisa, we heard about this pattern. What do you think about this pattern? Because the idea that this was something he continually do, it worked for him. He would drug women and then ultimately sexually assault them. That was the allegation with those women. That's what he was accused of doing here, and that's what he was found guilty of doing here. That pattern, in your experience, what does that tell you?
Well, we have 60 women who actually came forward. Only 5 actually testified. So a lot of the cases would have gone forward were it not for a statute of limitations. But using these prior bad acts, as Andrew said earlier, using them is extremely prejudicial. So as much as I would like to see the bad guy go to jail and serve his time, using these bad acts that he was not convicted for and having those come forward was prejudicial. And I'm a big believer in the criminal justice system and making sure that we do right by our citizens. So as much as I would like to see him serve his time, which he has a year, technically he's got a year left. Next September, at the bottom will be his 3 years and he could be out. So what could possibly happen if this is thrown out? Can he be recharged again without having the bad acts?
Okay, let's play this out. Yeah, technically could get out, but that's if they want to let him out. Again, the maximum is a 10-year sentence. 83 years old, Andrew. Let's say the court comes back, the Pennsylvania Supreme Court, in a few weeks, a few months. They say, you know what? This was prejudicial. He shouldn't have been convicted. They throw his convictions out. He gets a new trial is ordered. How does this play out? Do they try him for a third time? When does that happen? Where does he stay?
How do you not try somebody a third time? If you're so confident in the facts, you've got to keep going. I can't imagine the prosecution just throwing up their hands and saying they can't move forward. I think the biggest problem here, and what Ms. Allred is saying and what was argued before the court, is that this somehow showed that Mr. Cosby had a notion that the person wasn't consenting because he had done something to a different person that in this case, he couldn't have been confused about that person's degree of consent. See, I don't like that. I don't like that you're putting somebody's state of mind in one situation as proof beyond a reasonable doubt simply by looking at what he did to somebody else a long time before that, or at least disconnected in time by more than just that incident. Every incident should be taken on its face, looked at very carefully. Now, if there's some part of that that's just outrageous because of his prior knowledge of it, that's a different story. But to say that just because other people maybe had something similar that he would have known that there was a lack of consent here, I'm just not buying it. I think this case goes back to trial, and I think that it's going to be successful for Mr. Cosby if it is only the one allegation that is presented against him.
And let's be clear, this is not having any sympathy on Bill Cosby at all, because you want to talk about the law. Maybe the law is on his side here. I'll tell you where the law wasn't on his side. One of the other arguments brought forward by the defense was the idea that, Bill Cosby said, hey, I shouldn't have, no evidence of what I said in a prior deposition should have been brought in this criminal trial because I got a promise from a prosecutor that I wouldn't be charged with anything with what I said. And the Supreme Court said, what? Not really. First of all, it's not even clear you got a promise. And also you sat down for this deposition. What you said is what you said. So I really think, and I think we can all agree, it all focuses on whether or not these women should have been permitted to testify. We'll get a decision from the court within a few weeks, maybe a few months. We'll monitor it. But we're going to take a break. And when we come back, Tiger King, have you heard of it? I'm sure you have. There's a lot to talk about. We'll be back.
Now, this is an unprecedented case. And with this lawsuit, we seek to set a precedence to make it financially prohibitive that the police won't wrongfully kill marginalized people, especially black people, in the future. This is a crisis in Black America, a public health crisis. While all of America is dealing with the public health crisis of the coronavirus pandemic, Black America has to deal with another public health pandemic of police brutality. This is the tipping point. This is the tipping point for policing in America.
That's Ben Crump, the attorney representing the family of George Floyd out of Minnesota. The prosecutors who are charging the 4 men involved or allegedly involved in connection with the death of George Floyd are now objecting to how this trial will be broadcasted. This all comes after the court ordered the trial to be televised. So just to give you an idea here, and this is really interesting, they're saying that it should be limited and that the only things that should be televised are the openings and closings, testimony from defendants if they take the stand, and any witnesses who are okay with being publicly broadcast. Lisa, I'd like to start with you on this. How important is it for the world? How important is it for the defendants for this entire trial to be shown?
Transparency is everything right now because of the huge public interest. And this is global right now. This case is known throughout the world. Everybody wants to know what's happening. The issue that the defendants have right now is the fact that in the past, there were some leaks, and they want to make sure that everything is out there, plain and simple, broadcast audio, video, so that particular leaks are not misconstrued in another way. There's not a slant or a tilt in another direction. So the transparency of this, I think, is extremely important.
Let me just stick with you for a second, Lisa. What are the defendants hoping to show here?
Well, with everything being showed, not just opening and closing, and if they decide that they're going to testify for themselves, which I think is unlikely, I think they want to be able to show the video footage from the different angles in hopes of showing George Floyd's behavior prior to the entire duration and up until the ambulance had arrived. People have not seen all the clips, all the video evidence that's in there. So I think they want to show George Floyd in another light, possibly somebody who had swallowed drugs and how he was behaving.
Andrew, let me turn to you. Can the prosecution, can the state actually limit what we'll see? Will we only see the openings and closings? Will we only see the defendants take the stand? Will we only see witnesses who choose to be publicly broadcasted? Could that be the reality?
Well, my understanding of Minnesota law is that both sides traditionally have to agree to the broadcast, but that's not the only way in which it can be done, that a judge can overrule the prosecution's objection. Now, the prosecution is making these kind of nuanced arguments about what should be shown and what shouldn't be shown. At the end of the day, and I hope I speak well for law and crime in saying this, the idea of public trials is critical. And having the public be able to attend, watch, take note of, and show that interest in what's going on in a courtroom really is part of an American tradition. And right now, during COVID, the additional difficulty in getting into courtrooms to even have reporters report on it with different perspectives is very difficult. I think that right now we are at a cusp of American jurisprudence that the idea of public trials really will become much more ubiquitous. It should be, because we want to know what's going on in these courtrooms, and the technology allows it. It's not disruptive. It should be something that we see not only in this trial, but in many trials across the country.
Andrew, you want to be on the payroll for Law and Crime? That was fantastic. I mean, you should be the mascot for what we're trying to do here, so we appreciate that.
That's right. Well, I'm here
seriously,
too, Jesse. This is
case,
great
and
stuff.
We do
this is very important.
I know. And you know what? It's interesting because we're switching from such a huge and important case to, you know what? I'll say this is important too. How many of you out there watch Tiger King, the Netflix series? Constantly an update in that case, always the gift that keeps on giving. Well, the House, believe it or not, is going to vote tomorrow on a bill called the Big Cat Public Safety Act. And that would make it illegal to privately own tigers, lions, leopards. It would also limit public access to these animals that are owned by different facilities. And this legislation was inspired by the events of Tiger King, how the animals were treated in that documentary series. And someone who has been pushing this, of course, is Carol Baskin and her husband, Howard Baskin, who own and operate the Big Cat Rescue Animal Sanctuary. You'll actually recall that Joe Exotic Zoo was transferred to a guy named Jeff Lowe, and then a court ordered the zoo to be transferred from Lowe to the Big Cat Rescue. Here was actually his reaction to all that.
in all honesty, and people probably won't believe me, but she deserves this property. She beat Joe. He didn't defend himself, and she's entitled to the judgment. We didn't defend this suit because we knew, one, that the law would be on her side, and two, it wasn't worth us defending this property because we didn't want it. And Lauren and I tried to donate it to the Indian Nation about a year ago because we knew that there were the remains of a young American Indian boy buried here. And we thought that the nation should have the first opportunity to protect this land and his grave.
And that's what we're dealing with. So, Andrew, let me start with you. This is a big deal. This is a big bill. Do you think it's going to get passed? And what does this mean moving forward?
I have no idea what the caucusing looks like on this one. Gosh, watching that show makes you really shake your head and wonder if we should be having people have the ability to have so many animals that are so dangerous to put the public at risk, the low controls over it. But at the same time, I mean, part of the American tradition is having the freedom to do as you would please and to risk things on your own. The idea of a federal law that would restrict this nationwide. Traditionally, I think the Republicans wouldn't like something like that. But I think there's going to be a lot of support for the idea that there's some nasty stuff going on behind those fences, and people really don't have confidence in what's going on. And I'll say the same for Carol Baskin. I know she's got a rescue, but it never felt that way in the way that it was portrayed in the documentary. That's more of a rescue than it is just another business.
So I see you hanging out with Joe Exotic and Don Antle. I see what you're doing there. I see which side you're on.
I'm just looking for clients.
Lisa.
I'm looking for clients, Jesse.
Well, that's a good point because, Lisa, now let's say this comes into law. How does law enforcement actually enforce this? What are we going to expect to see in the months and years to come? Are we going to see these hidden, crates of animals being released, people hiding them on properties? What is that going to look like? Andrew's going to have new clients. So what is this going to look like?
So what the expectation is this: the people who actually own them now will be grandfathered in. The breeding is what they're concerned about. Are they going to continue with breeding? And as Andrew said, the Republicans are big on having the right to do what you want to do and the whole, entrepreneurship type of thing and to not infringe on that. The problem is, and what Carol Baskin brings forward, is the idea of them making income for the abuse of the animals. And that abuse would be starting these petting zoos. And this is not what it's about. It's about having a sanctuary for animals who were given up, who were abused, et cetera, with the hope of that dying down at some point because of them not continually breeding them for the purpose of abuse. So, I agree with it. I didn't even know about Tiger King. I grew up in Chicago, and our biggest issue there was huge rats. So having all of these lions and sanctuaries and tigers across the nation, this was very eye-opening for me.
Yeah, we don't really see it too much in New York City unless something absolutely nuts happens. And I don't think I'd walk into an apartment and see a lion just waiting for me. But this is a big part that happens across the country. And Andrew, do you expect to see a lot of criminal cases coming forward? Do you expect to see a lot of litigation? If this passes from a legal point of view, what should we be looking out for?
I think my only real point of reference is the documentary itself. There aren't that many of this community, people in this community. So it would be what I see as much more of these public health laws that are passed on a federal scale. And there's going to be some sort of administrative investigation into the goings on these various sanctuaries or businesses, and that could lead to fines or other sorts of enforcement mechanisms. This is not something that's going to be dragged into court initially on these criminal allegations of having cats, even if the law passes. This is just civil law, administration, sort of public health stuff that we see every day in all sorts of different industries.
And it's amazing to think about the impact of this Netflix series, again, how it helped to push this forward and raise awareness to this issue. And, that's totally aside from all the strange characters and the idea of what happened to Don Lewis and The fact that Carol Baskin now was on Dancing with the Stars. A lot of effects out of this, a lot of aftermath from the documentary, and I'm not sure a lot of people expected this would happen, but we will see the aftermath of that as well. We're going to take a break. When we come back, we have two other important stories we want to talk about, including the body of a social media influencer found on a Houston road. We'll be back. Welcome back. We have a sad story out of Florida we want to bring to you. A mother named Suzanne Penton died from injuries that she sustained weeks ago by allegedly being hit by a car filled with teenagers. It's a horrible story, and apparently she was protecting her son at the time from being attacked. The teens, ages 14, 15, 16, and 18, were originally charged with attempted murder, but now it seems only the driver, Elijah Stansel, is charged with murder. The other teens, of course, face different charges like burglary with assault and delinquency charges, and it's possible that they will be tried as adults, not juveniles. We learned a little bit more about this when the sheriff held a press conference. Take a look.
When he comes out the side door, Elijah immediately confronts him in the carport and starts beating him up, where a fight ensues. We see that Hunter tried to, or either was forced back into the house as a result of the fight. Elijah is fighting with Hunter. Raven gets a couple of shots in during the fight, the best we can tell with the pieces of video we have. And Hannah is taking photographs or video in this. About that time, unexpectedly, Suzette comes back. She arrives. When she comes back, we see that our ringleader here, along with the other two, just kind of hurry off back to their van. Suzette actually sees the fight. She gets out and goes to the van in her car. Suzette is trying to take photographs of the getaway van. Elijah Stansel runs over her, completely over her. She has tire tracks on her body where he runs totally over her. As we speak today, Detective Fulcher from our homicide team is on his way to the South County Jail, where he's still locked up, to charge him with murder.
Okay, Andrew, I'm going to start with you. They're charging this young man with murder. The others are not going to be charged with murder because they were not the driver of the car, but they could face being tried on those other charges like burglary with assault. How is this going to play out for all of them?
Well, it's going to play out very not well for these young people who are involved in this. We have to remember that a vehicle, thousands of pounds of metal hurling down the road at your direction with the gas pedal and the steering wheel is really no different than firing a weapon, a gun, because you are using this tool to severely injure or kill somebody else. It is a deadly weapon, and it was used in that fashion in this case, according to the reports from the police that we just heard, and relatively convincingly so. So unless there's some sort of defense here that woman who has so tragically passed away at this point was a deadly threat against these young people, there's no real good defense that I'm seeing right now.
Lisa, we heard a lot from Sheriff Grady Judge, a lot of facts, but what more do investigators need to look into? What do we not know yet? How is that investigation going to continue?
What angers me so much about this is exactly what police tell citizens all the time. When you see a crime, to get the license plate, get a photograph of the license plate so that you can report the emergency. This was a mama bear protecting her cub. Her son was being physically and brutally assaulted, and she went out there in the attempt to make sure that these people pay for it by simply getting a photograph with her phone camera. And ultimately, what we want to be able to see is that in order to go forward with this case is that they knew that she was out there doing that and trying to prove that physically she was in front of that vehicle. She ran out in front of it. He didn't have time to stop. That's the only thing that they could come up with as far as a defense. They had no idea that she was in front of the vehicle.
It's a horrible story when you think about it. And sadly, it's not the last one we're going to talk about, because there's another tragic story that went absolutely viral for all the wrong reasons. The naked body of 26-year-old social media influencer Alexis Lee Sharkey was found on a Houston road. Now, the autopsy is going to be performed, but what we seem to know right now is she had no visible wounds on her. And Alexis had been married to a man named Tom Sharkey, who says he's been helping with the investigation. He claims his wife was not happy before she left the house, and ultimately she was found dead. I mean, clearly at this point, they haven't ruled out foul play, but it's not clear if this is a homicide. Nobody has been charged. Sharkey, the husband, again, has been facing death threats. It's been alleged that he is responsible for what happened to his wife. There are allegations that they were fighting and going through a divorce. So, Lisa, let me start with you on this. How does this investigation, which is very early, we don't know a lot of details at this point, how does this play out?
We're going to look at timeline. We're going to have to look at her phone and find out who she was in contact with to find out when he reported her missing the next day. The body was found at 8:30, but they didn't identify and notify family members until Sunday, until they were able to actually ID her. He contacted her family the day after, Saturday. At what point? So fingers are pointing toward him because of the volatile relationship that has come forward regarding her friend saying that she was very private, but she was filing for divorce from her husband. And the fact that he said that she did storm off. What they need to do going forward, obviously, with the autopsy, we're going to find out. If you're not seeing any physical injuries on her, we can go back to either overdose or asphyxiation.
I was just going to ask you that. What does that mean? But, you know, Andrew, let me turn to you. If you were representing Tom Sharkey at this point, what do you tell him to do? What do you tell him not to do? And what do you tell him to expect?
Well, anytime that we are this early in an investigation, you don't know what's going to happen. So anybody who's potentially being looked at as a suspect, traditional defense counsel advice is going to be that you lawyer up and you don't make a statement until you have a good idea of what the evidence looks like and assert that constitutional right. On the other side, you've got the victim's family who is going to want as much information as possible. The police are just going to have to take the time that they need to investigate this. And I think Lisa's right on point. You got to build the timeline. That is detective work 101 here. And I'm sure we're going to hear a lot in the coming days about what was going on and exactly the circumstances behind this.
Lisa, let me stick with you for a moment on this, because no visible injuries, that's what we've been told at this point. We don't know what the autopsy is going to be revealed, but what we do know is her body was found on this road naked. What, in your experience, does that tell you? I mean, here's someone who didn't get rid of the body. Leaving the body naked is an interesting clue. And no visible injuries. You had mentioned possible asphyxiation. Could it be poison? I mean, walk us through what we do know. What does that tell us about what happened to her?
Right, we had a public works officer, a public works employee find her, and she was off to the side of the road in the brush with her feet hanging out. The fact that she was naked, and it makes me believe that she was taken to that location, that it was hurried. Whatever happened, she was killed somewhere else, and she was disposed of in that location, but disposed of in a way that she would be found relatively soon. The fact that she was naked, did something happen in her house? I mean, these are all assumptions that it happened in her house. And if it's possible that it ends up being her husband, had they been intimate prior to that? Had something happened prior to that? And then he just took her off and disposed of her body there, possibly. I mean, aside from that, you have a person who alleges that she left the house, she was upset, and we don't have any clothes, we don't have anything that's showing any identification at the scene where she was found.
It's just absolutely chilling when you think about it. And somebody who is so public, do we know all the details of their private life and what happened? Obviously, we can only speculate at this point, and we'll just wait and see where this case unfolds. Lisa, Andrew, I appreciate you taking the time here to speak about these cases. That's all we have for you on Law and Crime Report. We will be back tomorrow, 12 p.m. Eastern. We'll see you then.